Yeah, so technically, some of you out there think I'm 1 hour late. I'm actually 30 seconds early. All right, so for anyone who doesn't know, I hope we can hear me. Let me just go mic check 1 2. My blue snowball seems to be working better now. Okay, so here's the deal. I'm in New Brunswick. New Brunswick, for whatever the reason, is 1 hour more advanced than the rest of Canada, than Montreal. It's 8 o'clock where I am now. Also, for whatever the reason, my cell phone reception, just make sure there's nothing embarrassing there, nothing embarrassing. My cell reception has been bouncing between the cables in Eastern Standard Time and Maritime's time. So I don't know what time it is. Right now, just so you clear, it's 8 o'clock where I am. So when I set this up, I thought this was, I thought I set it up on the time zone in which I'm currently residing, but apparently I set it up in based on the time zone in Montreal because I was tethering off my phone when I did it. And so it set it up for 7 o'clock. I don't know how it worked, but the streams are never going to start at 6 o'clock unless 6 o'clock Montreal time, unless there's a darn good reason. So with that said, everyone, it is 7 Eastern Standard Time, and we are going live, and we have so many things to talk about this weekend that I didn't get through doing the homework that Robert sent me, and I love it. Robert sends me emails. We've got 21 items on the list, and then he sends me lawsuits, articles, links, and boom, I did as much as I could. I did more than most people would, not on vacay. But we went to Minister's Island today. Minister's Island. Okay, hold on. Let's back things up first here. I missed a super chat. Britt Cormier says, this is to remind Viva that he was late, and I have the screenshots to prove it. Okay, I can't bring this chat up because it's too far behind, but we will never start early, 6 o'clock Eastern Standard, without a darn good reason. It's going to be 7 o'clock. I'll be in Europe. I'll be starting at 3 in the morning. 7, 8, 9, 10, 11, 12, 1. 1 o'clock our time. Danny Robinson says, don't worry, Viva, you're not late. You're just very, very not early. Yeah, so this was set up an hour early. Minister's Island. We're in New Brunswick. It's I don't want to say the most underrated province because that's silly because every province has its beauty and every province has its foibles, flaws, whatever. New Brunswick is grossly underrated in terms of natural beauty, cost efficiency for a vacation, friendliness of the people. I love New Brunswick. I love New Brunswick. I know I Heart New York is already taken, but I Heart NB. So we went to Minister's Island today, which is an island which was initially an indigenous island. I forget which tribe or which native group owned it. It was subsequently acquired by one William Cornelius Van Horn with an E. And it's an island that is only accessible during low tide. And they built a road between the mainland and the island. I keep saying it. The mainland and the island. It's got a mansion. It's got a barn. It's beautiful. It has deer on it. It's got shoreline. It's magnificent. I went there and I did a Eric Swalwell vlog to talk about that, which is on our list today. But New Brunswick is just beautiful. If anyone has never been here before, you have to come. It's like Maine, except it's not America, and it is half the price of going to Maine in terms of vacation costs. Okay, we've got Bill Colbert is late and did not do his homework. We had such high hopes, but it seems he is just a human. All right, before I get into my rant discussion, we're going to just do some chats here. Can you do a breakdown of the Tiger King sentence reduction? We're going to talk about it. I that's news to me, but not to say politics ruins everything. It did seem that the Tiger King might have been spanked a little harder than he deserved. I'm not late. Okay, Boomer, whatever you say, Boomer. And Ewan Barnes ready to cover Virginia versus Sony Shoe. We've got 21 items on the list. Half of them I'm aware of. Half of them I am sufficiently aware of to maintain a conversation. You are the Lyrus. No, Ted Skoranek the second, 2021. I like the super chat price because it's 2021. Okay, let's get into the standard. Don't want to live like a. Okay, I'm going to get into the standard disclaimers. Okay, so first of all, thank you all for the super chats in advance. The support, YouTube takes 30% of super chats. If you don't like that, don't give a super chat. I understand that. You can support us on vivabarneslaw.locals.com. You're going to hear Robert say that multiple times throughout the evening. What else? Super chat, I will not get to all of them. So if you're going to be miffed, if I don't get to them, don't give it. I don't like people feeling miffed, rooked, shilled, grifted, whatever. I don't like people feeling that way. If you're going to feel that way or say that you feel that way, don't attempt to support us here. I don't like feeling bad. No legal advice. No legal advice, not no eagle advice. Okay, now, what do we start? What do we start with? Updates on the Viva PPC journey. We hit 10,000 subs on that channel, which is amazing and glorious and inspiring and encouraging. I've been posting episodic updates of my life, of the subject matter as we go through this, as I do the Viva running for office. I read the chats. I read the comments. People saying I'm too nice. I'm going to get destroyed. Politics is going to ruin me. Okay, fine. In doing some research for the episode 4, which was For the Love of Nature, Rumble is down according to Locals chat. Would everyone be kindly enough to go check on Rumbles to see if we're still there? Rumble. Okay, let me see here. Live stream. Okay. Trop de droit. Yeah, it doesn't look like we're live on Rumbles. That was the other thing I was going to get to. No Rumble ruins everything. Okay, so it looks like we have a problem on Rumble. What can you do? Viva, no stream on Rumble that I can see. I don't know if that's my problem or if I did something wrong. I'll have to assume I did something wrong because that's the way things are going tonight. I will be miffed if you get to this. Be miffed, Thomas Plummer. Now I'm wondering if I did something wrong on Rumble, but I set it up on Rumble, so it should be there. What are the chances that Barnes' first 2 words are good? Good. I think it's about 100% to 150%. You're good. Okay, so Rumble is down. You're good. Rumble is down. Not going to read it. I'm just trying to see what's going on here. Must be your intro video. No. Okay, well, don't blame Rumble. It might have been me that set it up improperly. All right, so let me just go to the list of homework. No, forget it. I was going to talk about what I learned. In episode 4 of Viva PPC, my time is wrong. No, there's no time on Rumble. I didn't set up a time. It just goes live. It's probably my fault for Rumble, so my apologies in advance. Just, I guess we can let everyone know there. For the love of nature, in discussing things with people, I'm seeing now that people have a lot of impressions that people believe things that they believe to be true that are in fact wrong, that are wrong despite how they believe these things to be true because they've never questioned themselves or fact checked themselves. And I'm guilty of this as well. I mean, I just had an argument with my kid about it was something about YouTube and TikTok and a character, and I was like, no, I know that it's wrong. And it felt so good to be right until I figured out that I was wrong. Because to quote that TEDx talk, to be right and to be wrong feels the exact same, right up until the time you find out that you're wrong. So I'm doing something. People believe things about the PPC. They believe things about the PPC stance on the environment that are just wrong. It's just wrong because black and white policy decisions. You can go to the websites if you want to check these things and look into them. Is Rumble Canada based? Would it not be affected by the upcoming censorship laws? No. I would not. Before anyone gets crazy on Rumble going down, I would just assume it's my mistake and something I did has occurred. Okay. So people assume things to be true because they take them for granted, and then they don't appreciate that they're wrong because they just never check themselves. In the environment, when we talk about the environment, for anybody who doesn't know, Canada has a carbon tax that has been in effect. It was implemented a few years ago. It was challenged constitutionally because it only was implemented against 4 provinces who refused to implement their own carbon tax regulation. It was challenged on the basis that the federal government could not legislate a carbon tax interprovincially because it basically usurped provincial powers. Supreme Court said it's constitutional, 6-3. Of the 3 that were dissenting, 2 were dissenting, 1 was somewhat dissenting. Setting aside the constitutionality of the legislation, Canada has imposed a carbon tax. So companies that emit over a certain amount of carbon emissions, however they measure it, we don't need to get into it, they pay a tax. They pay an amount for every cubic meter, whatever metric ton they're measuring. They pay a tax on that. The tax apparently stays provincially, is dispersed to the citizens, dispersed for green energy reinvestment, apparently. The tax is scheduled to quintuple by 2030. So what's $30 per unit now is going to be $150 by 2030. And it's a carbon tax. It sounds great. We're going to tax carbon emissions to save the environment. In just questioning that to myself, I said, okay, it's great. We're going to tax emissions in Canada. What's going to happen? People are just going to take those emissions. You're going to outsource emissions. And I said, logically, that's what's going to happen, not knowing anything more. And I just do a minor amount of research and find out that that's exactly, in fact, what's happening. And there's a term for it, carbon leakage, is that we are, in fact, simply outsourcing our pollution while simultaneously crippling our nation and rendering ourselves economically dependent on foreign countries for our manufacturing, who do it in a way that is just as environmentally unfriendly as what we are trying to stop at home, if not worse. And so the ultimate irony in all of it is you cripple your own local economy. You become dependent on foreign countries who are not abiding by these environmental laws, and they continue to pollute. So you've achieved strictly nothing from an environmental perspective, but you feel good about what you're doing while crippling your national economy. That's one thing. And so then looking into it, I said, all right, China, we all know it's outsourcing to China and India. Basically, China's the biggest polluter in objective terms and in per capita terms. But objective terms, China pollutes more than all of the developed nations combined. I don't know who exactly is included in developed nations, but they pollute more than all developed nations combined. Okay, that's fine. Per capita, though, they're not so bad. Per capita, Canada, Australia, and the US are pretty bad. China's still number 1, but the US, Australia, and Canada per capita are close. Per capita. So imagine this, that the number 1 polluter in the world, greater than all the developed nations combined, it gets to reduce their global emissions on a per capita basis because they're also 20% of the globe. So the biggest polluters and the biggest country in terms of population, if overpopulation is a problem. Can someone stop turning off that light, please? Get to amortize their pollution because they happen to be massively overpopulated. That is counterintuitive and counterproductive in a way that does not need to be stated, yet it seems to need to be stated. Where Canada, a country that is massive and very much underpopulated, is going to have certain needs that can only be met, based on the size of the country. It's going to require a certain amount of output. But if we had 100 million people, our greenhouse emissions probably would not go up 3 or 4-fold, just given the geography of the country. But because we're underpopulated as a country, we get to be bumped up on the per capita pollution so that we can now use it as an excuse to cripple our national economy, to become internationally dependent on China for manufacturing and production. It's a backwards logic that makes no sense. So that's my rant, is that nobody understands these fundamental issues, which you only start asking the questions, then you start finding out the answers, and then you start realizing the discussion itself doesn't make sense. All right, with that said, food for thought, think about it. I see Barnes in the house, and I want to bring up some super chats before I bring him in. All factories will be built on the border with another province, so the carbon blows right over the border, problem solved. So someone said, Viva, you're just like a typical, whatever. You talk about the problems, but not about the solutions. Here's one solution. Eliminate the carbon tax so that we're not outsourcing pollution to a country that doesn't care about the pollution while crippling our country and becoming dependent on that country to outsource our pollution so that we can just get our crap that we don't need, that is environmentally unsound at a cheaper price. Here's one thing: eliminate that tax, and you're going to already do better for the environment because you can manufacture at home without being reliant on the countries that are not respecting the environmental regulations, because they're all voluntary under the Paris Accord anyhow. That's one solution. Okay, with that said, not only do those other countries cause more pollution than manufacturing, there's also added pollution from the transport of the goods to Canada. That's another thing. People don't know what the number one carbon emitters are. Steamliners, these ships that ship the stuff from China to Canada. Setting aside Justin Trudeau's personal flight so that he can go to the Great Britain Isles there for the G7. You know what does not emit carbon emissions? The bagel shop in downtown Montreal that are being shut down because they don't want to have wood burning stoves because it's bad for the environment. But those freight boats, which are the greatest polluters on earth, run back and forth. Trudeau takes a private jet to go to a G7 summit in the Great Isles of wherever in Britain. Can't do it by Zoom. Yeah, whatever. It all sounds good until it gets individual citizen and it will want to work out. That'll be $20 in climate credits. Here's another thing. Give citizens credits, tax credits, for buying environmentally friendly and green products. Here, those are three solutions. Bada bing, bada boom. Let's get the stream started. I just saw a red super chat. Did I miss it? I missed it. No, I didn't miss it. It's down here. Okay, Robert is waiting impatiently. I can't find it. Brendan Saltvik says, Posobiec reported White House is pushing for lockdowns again, said that blue states will comply. What can we do in the court of opinion if you live in a blue state? Okay, with that said, your kid toggling the light and giggling made me giggle. Vacations require, at the very least, 1 week to downgrade to vacation mode. We've been on the vacation for 1 week. We finally downgraded to vacation mode, but we still want to. There's at least an hour a day where everyone is going to strangle each other in the house. Okay, with that said, Robert, I don't know if I set this up 1 hour early based on time zones, but you're here, and that is as much as we need. How are you doing?
Yeah, I think it's the right time. As far as I know, it is.
And by the way, 100 people just lost a bet because this might be the first time your first words are not good. But yes,
oh, right.
the bets are over, people. Robert, there's so much to talk about this week. Look, I don't know where we start. First of all, is anything new happening in anything that you are dealing with that you want to apprise everyone of before we get started?
Not particularly, other than there are a couple of vaccine lawsuits that have been filed, a mask mandate lawsuit that's been filed. I'll be involved in a case against the FDA trying to rush the authorization of the vaccine, full authorization. But all of those matters, along with the election audit results that Matt Brainerd has and some others, I'll be discussing at vivabarneslaw.locals.com to get around the YouTube censorship issues. So if you're interested in those topics, go there, and that's where I'll be discussing them throughout the week.
All right, Matt Decker says, let's do interstate Vaxports. Hold on. Did I tweet today Vaxports was the new term I was going to coin? Because I swear to you, today I thought of that term. Although I doubt, by the time I thought of it, 1,000 other people who are smarter and wittier have already thought about it. We might get there because we'll have some questions, and I know other people will, and we'll dance around what we're allowed to discuss and what we're not. But let's start with number one, which is the freshest in my mind because I just read the judgment. And I don't know what Cuba Gooding Jr. is thinking. Now, for anybody who doesn't know, it's been in the news, so I don't think Cuba Gooding Jr. is going to say that he's unaware of the lawsuit anymore. Cuba Gooding Jr. was sued civilly for a crime of a sexual nature of the most egregious kind. He was sued in 2020. The event allegedly took place in 2013. From what I understand, the plaintiff, who is unnamed, and we're going to get to that, I don't think she filed criminal charges. I may be wrong, but you'll correct me, Robert. She filed a civil suit in 2020, anonymously, asked for permission of the court to remain anonymous, asked for permission of the court to, I guess scrub is the wrong word, but close enough, documents which contained her name so she could retain anonymity. And then when Cuba Gooding Jr. failed to appear or neglected or failed to appear, and that is formally announced that he's going to defend, that he intends on defending, that he's got a lawyer. A year later, she filed a motion for judgment by default. There was a procedural issue where she was her lawsuit was dismissed without prejudice. You'll explain to me why, but it was dismissed without prejudice. She refiled, continued default, got permission to serve Cuba Gooding Jr., served in accordance with that judgment, failure to appear, respond, whatever, and the judgment that was rendered against him granted her motion to remain anonymous, to scrub her name from certain documents, and judgment by default, monetary damages to be awarded later at a hearing in September. I don't think I missed anything there, but explain to me just the first question was that I had reading this judgment was why her lawsuit was dismissed without prejudice in the first place and what that meant.
So she filed the suit, I think, right on the eve of the pandemic, and then didn't follow up, didn't attempt to serve the suit. So it was initially dismissed for failure to prosecute by her. And I think it references it as being a her. And then the plaintiff, and then and so that's why. And so but they allowed her to reinstate her claim and then serve him. And when he did not respond, the court issued a relatively quick default judgment against him. But one of the things he'll have grounds to try to set aside the default judgment. But there's an increasing use of default judgments in some problematic ways. I was involved many years ago in a default judgment case against Pepsi that the courts were eager to set aside, even though there was no good grounds to set aside, just because of the size of the judgment and because of who Pepsi was. So we'll see whether the courts step back from that. There's all kinds of grounds to set aside a default judgment, but courts are getting a little tougher at allowing that to occur. But notably, one assumption is a default judgment automatically means the monetary amount is assessed. For due process reasons, that's not supposed to happen. There's supposed to be a separate, what they call a prove-up hearing. And the judge in the case has ordered a prove-up hearing in September and basically implied that if he doesn't appear for that then, of the millions of dollars that the plaintiff wants will be received. The case is a reaffirmation of the right to file suits anonymous, the rights that you shouldn't have to forfeit your right to privacy in order to get relief in the legal system. I filed the Covington Boys cases as all anonymous for the same reason, and it was good to see reaffirmation of that. But otherwise, it's a reminder that you get served a suit, you should get a lawyer, particularly if you're Cuba Gooding and you might owe millions of dollars otherwise. Only other caveat is I think this case, we don't know because we don't know the plaintiff. This case may be related to a prior criminal case that ultimately did not lead to his conviction. But it's a little peculiar that he didn't respond. But sometimes with celebrities, I'm very curious about what the service of process really was. Was it on him? Was it on somebody else that didn't get the message? But sometimes this happens with celebrities. They're so hard to reach and they're so protected that they don't know that they've been sued for millions of dollars and might be on the $1 million losing end of it, as Cuba Gooding right now looks to be.
So just to address one comment that someone said, the defendants or the accused have the right to confront their accusers. It was stipulated in the judgment. The judge said Cuba knows who the person is, so there's no reason to make it public for the rest of the world. So it's not like Cuba. He's not facing an anonymous, what's the word, blacked out type face type thing. He knows who it is because her name appeared in certain documents that were served on Cuba. They just want to have this not made public. And the reasons are pretty clearly set out. I mean, this is a high-profile case. The woman's going to lose all anonymity. The plaintiff is a woman, given the nature of the allegations, which involve certain types of assault. And so this is the question now. Everyone looks at this and says they're going to come to their own conclusions. Cuba got served. He decided to ignore because it was so frivolous. He didn't get served because he's trying to dodge service. He didn't get served because he couldn't be found. And he is a celebrity. They are behind multiple layers of protection. He may never have known this lawsuit even existed in the first place. Now he certainly knows. Doesn't matter. End of the day, if this is anything like it is under Canadian law, he will have a chance to come in front of a judge and say, look, I never knew this lawsuit existed. Other than the delays, no prejudice in striking this judgment or bringing us back to square one. I intended to defend. Obviously, I wanted to. And so, what's the word? Strike the decision granting the judgment by default, and let's contest this, and we'll agree to an expedited hearing. More likely than not that happens.
It should, unless I've seen some tendencies recently with judges being harsher about that. But the law is supposed to be, and this is a federal decision, but the law almost everywhere is that the law abhors a default. that the law prefers to have the merits determined and decided. And so here it was, he didn't appear for a couple of weeks within the time frame. It was one of the fastest default judgments I've ever seen issued. So that would make you a little concerned about where the judge's mindset is. But my assumption is if he retains counsel, he'll move almost immediately to set aside the default judgment, not just go to the evidentiary hearing on the prove-up side of the equation. He's going to contest everything. But and there's often good grounds to do so. But it can be tricky. It's always a risk not to appear or file something on time.
And there were references. I mean, this is in the context of Cuba Gooding Jr.'s broader criminal and social media accusations. Like some of them are criminal, some of them are just where the battles are being taken now. It's in that context. In that context, people are going to say, yes, it's a legit plaintiff. Others are going to say it might be someone who's being an opportunist, trying to exploit that context for the purposes of ill-founded accusations so they can seek a monetary award. We know nothing of the evidence right now. Thus far, it's the lawsuit that was served, allegations that Cuba was validly, duly served, but did not respond, and therefore that justified the judgment by default. So people out there can think that Cuba Gooding Jr. was not sitting there hearing a bailiff knock on his door and refusing to answer. There are circumstances in which valid service can still be slipped into a mailbox, stapled to a door. I mean, there are forms of service that people don't know exist, Robert.
Yeah, and in particular with celebrities, they may have had an agent of some type at their known residence accept service of process and then not relay the information or documentation onward. It's very hard to see why he would not appear at all. That just doesn't make much sense. Particularly, I mean, right now he has a judgment against him for the kind of thing you don't ever want a judgment issued against you for. So I don't see what his motivation would be to actually not show up in the case. My assumption is that something just slipped through the cracks for some reason. But it shows, the important. Someone in his position really should have, lawyers on cue that are always notified of any legal action, or even, tracking filings in state and federal courts. Lawyers can do that if they can track by party, depending on the state. Some states don't have the best records, but all federal courts do. So if someone was just tracking each day to make sure his name wasn't showing up somewhere, they would have caught it too. He clearly didn't have the best protective team around him, and that's why he's in the jam he's in right now.
Yeah, it's because for anybody who might be thinking, I think it was actually McAfee who said, I'm not going to defend against certain things because it's not worth my time. But this is not the type of thing anyone makes a strategic decision to ignore. These are the most serious accusations, which, okay, fine, not criminal. I'm reading all of the favorable media, BuzzFeed, what was the one, Variety. Yeah, it's not a criminal condemnation. It's just a civil condemnation, as if anybody wants a civil condemnation on the record, even if your damages are $1, that this is a judgment by default.
Not for this. I mean, it'll be interesting to see how the Me Too world reacts to all of this. Because right now, Cuba Gooding has a judgment against him for sexual assault. That's the reality. I mean, and that's why it has broad impact beyond whatever the monetary amount ends up here, or whether he gets it set aside or not. His career is in jeopardy by not responding in a timely manner.
All right, now that's about it for that. I mean, we'll see what happens. I suspect they're gonna undo the judgment by default because it's as a matter of pure equity. If he announces now, I want to defend, but I didn't know, any normal judge would do that without making it too hard. We'll see. To be continued, I guess. And speaking of due process, some more of the homework you sent me. This was going to be my vlog for today, but it was too complicated to do a vlog on while on Minister's Island with, I had a window of 10 minutes today to do a video. The Johnson & Johnson talc powder lawsuit, what do we call it? It's not a class action. It's not a joinder of actions, but a multiple defendant lawsuit. For anybody who doesn't know, Robert, it was in Mississippi, correct?
Yeah, so, there's two different parts to this. So the original big case was in Missouri. Johnson & Johnson lost their Supreme Court petition. And then this week, another suit was filed on behalf of a Black women's organization related to all of the findings that have already been made in these other court proceedings. So Johnson & Johnson was selling their baby powder, almost I remember it.
Yeah, it smelled great. I mean, everybody used it. And I remember reading the decisions, the articles coming out that they were sentenced to At the time of the original jury condemnation was $4 billion.
That's right. It only got cut in half because the Missouri Court of Appeals said that there wasn't personal jurisdiction over all of the parties. There was for some of them, but it was still a $2 billion judgment, and they couldn't get the U.S. Supreme Court to take it up. And so, and then they have other cases against them as well across the country. But the interesting thing that added to it this week was the filing that reminded people that Johnson & Johnson, and again, Johnson & Johnson is a maker of a particular product right now, in some controversy, just a little reminder, as its other maybe relevance as to the trustworthiness of some of these companies that are making these products.
Robert, we all trust big tech now. It's quite clear. Big tech. We all trust big pharma, and you can't question it lest you get kicked off social media. So yes, we have paid a tithe to the big pharma overlords.
I would never distrust a company that's going to make billions of dollars and has zero risk of liability myself.
You made that connection. I did not yet make that connection because the only company I'm paying attention to on that front is Pfizer.
Right.
But you've poisoned my mind with that connection. But with that said,
their particular product was in question from early on. But that's who this company is. I mean, one of the products sold is one of its safest, biggest products. Turned out it could give you ovarian cancer. So and we can say that now because the jury has already concluded that, and it's a final judgment.
And just so we're clear, talc powder. We're not talking about anything else. Baby powder, talc powder. This is the level of my neuroses. I'm so neurotic that even when I had, we put it on our kids' butts. I don't enjoy the idea of inhaling any fine particulate matter, regardless of what it is. I don't care. When you're smelling something, you're inhaling something. Someone's gas, you're inhaling it. Talc and these what they call hydrophobic powders, I don't like inhaling them. So I never liked inhaling baby powder. I never liked using it. But the bottom line, I read the judgment. The judgment was not the judgment, rather the motion for cert or the request for cert. It was very well drafted. It was very compelling because you do appreciate, as Johnson & Johnson alleges, regardless of whether or not you hate them, that you're in a situation where plaintiffs have gotten very good at, it's not forum shopping even right now, it's plaintiff shopping. They go around and look for people who fit certain criteria. And when you're dealing with 350 million people and talc powder, which has been sold to pretty much, let's just say, half of the country, you're going to find, if it's not connected illness, at the very least, coincidental illness at a large enough scale that you can file suit and draw some correlation to. So bottom line, it is alleged in the petition for cert that was denied, I guess, that these plaintiffs went looking around for people who used talc powder and subsequently developed cancer and ovarian cancer. And they lumped them together in lawsuits and then brought the suit in a jurisdiction that they felt was favorable, even if a number of the plaintiffs were outside of that jurisdiction. And even if the plaintiffs themselves had different illnesses or different degrees of illness, different degrees of remission or cure, some died, some got better, different damages, everything was different, except they lumped them together in one jury trial and then instructed the jury to treat all of these individuals as different plaintiffs and not as one lump plaintiff. And what I found most shocking was that apparently the jury instructions lasted 5 hours in this case. So for 5 hours, they're instructing the jury on different jurisdiction of law. They're instructing the jury on, don't treat these defendants as equal. You have to treat them all as individual defendants, even though you're called to adjudicate on it effectively in one big judgment. Some of the plaintiffs suffered different illnesses, different degrees. Some of them didn't even use the product, but had, it's alleged they had dreams of having used the product. And then the jury comes down with magically the same monetary damages for all the plaintiffs and a punitive damage which apparently exceeded the ratio of punitive to monetary damages. So, look, that's the broad overview. It's complicated. I hope that does it justice. But Robert, explain the first thing. What is under the law in the United States the principle of law as relates to punitive damages ratioed to monetary damages?
Well, I mean, in my view, there shouldn't be any ratio, but the U.S. Supreme Court has said there is. Justice Breyer famously said it's a rule of thumb. which I found ridiculous. But that's our Supreme Court standard. Maybe it's excessive, maybe it's not. And it just depends on whether the Supreme Court is personally offended, frankly, as to whether they take the case or not. But basically there has to be some proportionality. You can only look at harm done within that state. For example, you can't look at harm done outside of the state if it's a state court proceeding, things like that. And here the amount of damages collectively was about 550 million, 25 million each across 21 different plaintiffs. And then they did about 3.5 billion, which is about basically if you're under 10-1, you're going to be okay for review. Unless you have now I have come up with creative facts. My view is don't analogize it to monetary damages, analogize it to criminal punishment and penalty, and compare it to gross revenues of the entity. So if somebody could serve 5 years in prison for this, then give me 5-year profits for it. That should be, if we're going to treat our criminal punishment system comparable to our civil punitive damages system, that's the comparison we should be making. They don't like that because there's only one group of people really worried about punitive damages of a big size, and that's big corporations who get caught doing something bad. And that's why the courts are eager to, we got to have some due process here. We can put grandma away for 6 months while we can't get a trial for her on January 6th. But by golly, that big corporation, poor BMW, they didn't mean to screw that up on the paint. That kind of reality. But they basically lost that side. But with the undertold story, now people can question some of the lawyers involved with the new suit, but it is a known fact. They particularly targeted African-American women for this product. So they basically, and were disproportionately, and what hurt them was usually these kind of toxic tort cases are very hard to prove causation. They usually do a good job, the corporate lawyers, at getting the cases severed, making you do the liability in one side, damages in another, so the jury never hears the sob story, all that. People can watch a really good film or read a really good book called A Civil Action to show you how tough toxic tort cases are. That's in the environmental context. We'll be having no sidebar this week, but a sidebar next week with Bobby Kennedy, who did a lot of had huge success. And it may be why he went from, environmental tort, toxic tort, to dealing with big pharma and the vaccine and other contexts. People didn't realize there's actually maybe there's a logical connection once you understand what some of these companies are up to. But it's an interesting suit, and it's interesting the media has not talked about it much, given the political people involved, given the clear racial discrimination that took place. I mean, the thing that hurt Johnson & Johnson was that through the 70s and 80s, they knew this, and they hid it. They hid it from governments, they hid it from regulators, and obviously, most importantly, hid it from consumers. They had spotted the problem with their product causing cancer in one of their most mass-marketed products, and they just, hide and lied. And that's why that jury didn't care about differences between plaintiffs, different stories. They were going to whack Johnson & Johnson, and in my view, deservedly so. But this new suit exposes a new problem of big corporate America targeting and discriminating against particular groups for their product in particular, causing cancer, mass cancer, and for African-American women especially.
So, Robert, I mean, I read the motion for cert. It admittedly, obviously, it's drafted by J&J's lawyers, and they raise some good points. When you sell a product to, let's just say it reaches 150 million people get cancer, people get ovarian cancer, people get all sorts of illnesses. What evidence, I mean, do you know, are we aware of what evidence was adduced to actually, prove the causal connection between the talc powder and the type of cancer at issue? Because from the cert, it sounds like there was no evidence. Obviously they're straw manning probably the plaintiff side, but what was any evidence that there was a correlation between the talc powder and ovarian cancer?
There were two different things. And by the way, the lawyers who wrote that cert petition are famous liberal Democrats, by the way. So it tells you where they really are. Neil Katyal and some other big names on that group. It's a reminder, you're in the African-American community, who really is on your side. But they had 30 experts is my recollection. There was a 3-week trial that testified. And the key thing again was their own internal documents. It was Johnson & Johnson's own people flagged, this looks like this causes cancer. Well, what do we do? Keep selling. That's what they did. And what is they went up against some very tough plaintiffs' lawyers. because plaintiffs' lawyers learned from the big tobacco suits how to hold people responsible. And one of the keys was joinder, forum shopping, pick the right jury pool, pick the right judge, pick the right county, pick the right state, and all the rest. And the real reason I think neither the Missouri Supreme Court nor the U.S. Supreme Court would get involved is because when you see that Johnson & Johnson knew about it in the 70s and 80s, your sympathy kind of goes out the door, even if they had some technical claims that had credence to them.
Okay, but that is where it's damned by your own documents that people can have a very tough time contradicting. So I read the second was a motion. It was the it's a black. I don't know if it's a black rights group who's suing, but it was clearly
national. I think it's National Black Women's Organization or something of that effect.
So now here's the question. It's another ignorant question from someone who doesn't know better. I mean, how does Johnson & Johnson or how does any company target a specific demographic for advertising or for a product? Like what does that mean?
Marketing. It's in marketing and distribution. Where you distribute it, where you market it. Big tobacco was infamous for this. So and in fact, drug companies do it in general. Arguably opioids targeted poor working class whites and rundown communities as an example. Which counties, which cities, where they advertise, how they advertise, to whom they advertise. You can buy ads specifically for, I want black mothers between the ages of 35 and 55. I want white grandmas between 75 and 90, whatever, because all those demographics are available through Nielsen ratings and the rest. Political campaigns do it all the time. And so they both targeted them in their advertising and they targeted them in their distribution. Which stores you put it in, which stores you cut a deal with to promote it, all that kind of thing. And so which doctors you cut deals with to pitch it. And the other utility to this is, like I said, it might be a preview or it might be a reminder of how these particular companies operate given the current space they're operating in. And how if they would lie about this for decades, wouldn't they lie about something they can't be sued over?
Now, Robert, but you're talking about unknowns that we don't know about. And right now, all we know is that what we're being told by a government that changes its tune literally every month. And I'm not saying that to be contrarian. Who was it? I posted something on Twitter where Biden is now saying, when I said the thing about the masks before, it was true at the time. If the science and the directives change this much from one month to the next, turn that light back on. We're being led and governed by I won't say fools, but by people whose opinions change from one month to the next, and that's fundamentally unreliable governance. Okay, so the petition for cert was denied. So Johnson & Johnson is stuck with what was halved was the $1.5 billion judgment.
It's a little over $2 billion now. So they're writing some big checks, and now they got exposed on this other side. We'll see how that develops, but it's both preamble to what may be going on right now, warning at least to what may be going on right now, and it's a reminder of who these companies are. And it was a good win for the plaintiffs to hold Johnson & Johnson responsible. And this new suit is a reminder of their particular targeting. Like, for example, the Biden administration is flummoxed at why certain people are not interested in a currently distributed medical product from Big Pharma. By particular constituencies and communities. And it's not based on party. It's based on other narrative histories. But this case might be a reminder of why that is the case. And what's interesting is the remedy they're seeking, what they're asking for is something specific. They're not looking for monetary damages. They want Johnson & Johnson to advertise to really the whole world, but definitely to African-American women through all available means and marketing that they used to sell their product in the first place to them, to tell them, by the way, we lied to you and it causes this harm potentially, which I'm sure Johnson & Johnson doesn't want to do. But it was an interesting suit that seeks a very unique, specific remedy.
All right, and the denial of cert was it a short judgment? I didn't read it. Was it a one pager or just a one-liner?
It's one sentence. When they deny cert, it's just one sentence.
Now, finish up on this one for the Johnson & Johnson. They raised an argument which I thought was interesting, but almost hypocritical is not the right word. They said if the courts sanction these multi-billion dollar punitive damages, it's going to bankrupt the companies and frustrate the company's abilities to actually right the wrong, to remedy financially the harm because they'll go out of business, and then the plaintiffs are going to be left without a company to pay them their settlement. I mean, it's an interesting argument. It's sort of like saying, let us continue making money off our wrongs so that we can pay the people who have been wronged from our wrongs. I mean, asking the obvious question, what's your take on that argument? And what do you say when they say, like, yeah, the asbestos companies are all out and people are screwed with cancer now and have no remedy because of the amount of the judgments? What's the retort to that?
The general retort is that in terms of damages, they can set up a fund like the asbestos companies did to make sure people are compensated for their injuries. And if you get a punitive damage award that leads to your bankruptcy, then that's a jury's determination that that's an appropriate thing because they take into consideration what your revenues are. Now, Johnson & Johnson is at no risk of bankruptcy. This is a hit, but it's by no means a mortal one. Again, this company was one of the prominent companies pushing the current new product. So keep that in mind.
And now we got someone who takes issue with you referring to black people as African American. I don't know if it's a troll. I don't know if it's intended to be sarcastic humor. The reality is, Hydra P, at some point we all have to use the terms that people are saying are the correct terms. I referred to the Aboriginal community as Aboriginal in the video, and someone says, Viva, you're going to get in trouble. That's no longer the right word. It's indigenous. We use the term. If anyone is suspecting anyone of ill intent, racism, or whatever in our circle of YouTube and social media, you're in the wrong place to be making those accusations. I know the way Robert's using it. It is not ill intent whatsoever. And so we can end it there. But thank you for the super chat. Robert, with that said, what does this segue into properly?
Well, speaking of lawsuits involving medical issues, there was a good lawsuit brought by an organization, the Informed Consent Action Network, I think it's what it's called, ICON, against the government, because the government was hiding a range of information about the studies concerning the safety and efficacy of the current COVID vaccines. The suit did not concern whether they were actually safe or effective. It just concerned FOIA information that someone is entitled to under the Freedom of Information Act to know what the studies actually showed. And rather interestingly or peculiarly, the government didn't want to release a whole bunch of information about that they had from those studies. And they lost in court. They didn't lose across the board, but they lost on a bunch of key issues. And, maybe it's a coincidence, maybe it's not. But once that precedent had been established, not long after, all of a sudden, the CDC started talking about some other recent studies that raised questions that have us in our current political predicament of what to do with the new mask mandate discussions and new lockdown discussions and the rest. But it's probably a product that transparency is probably a product of that FOIA suit. So it was a very important FOIA suit in a very important context where people should have the most information possible. And the government was trying to hide it, and they were forced to disclose it. And it was a critical case, sort of under the radar case, but a very important. But the government was paying very close attention to it. Some of us paying attention to these issues were monitoring it, and it was a very important judicial ruling because the court said there's an absolute public interest in this information, particular information that goes to safety and efficacy of a government produced in part medical product that large numbers of people are going to be taking.
What I still can't get over, you've poisoned my mind. I'm not going to be thinking about anything but this, the Johnson & Johnson immunity now. Everyone is now going to appreciate in 10 years' time, potentially, hopefully not. This is not a case of every fear hides a wish. Immunity. If talcum powder, if only they had gotten immunity from mothers back in the day, they could have avoided this problem entirely. Okay, Robert. Well, let's go to one that I'm very familiar with. The Eric Swalwell, the man. When I did this video today, the internet is so funny because, first of all, before I published that video, my wife watched it and she said, "Oh, Dave, isn't Swalwell the guy who had the Chinese spy girlfriend?" And I was so proud for a moment because she remembered, she knew, she watches, she learned, and I forgot to mention it. And my goodness, is every other comment in that video, Viva, Swalwell's not known only for his fart and nukes. He's known for having a honey-potted relationship with Fang Fang. I think that was her name. And I'm not trying to be mean. I think that's the nickname that he had for her. A Chinese spy. But that's the backstory to this, is that Swalwell Eric Swalwell, rep from California, sued Donald Trump, president at the time, for whatever was left, Donald Trump Jr., Giuliani, keep getting his name wrong, Mo Brooks. Mississippi rep, for damages as a result of their speeches, which incited. Make sure everyone sees this. I'm not agreeing with this. Incited the riot, the insurrection. I feel like Chris Farley in Saturday Night Live. He sued them for damages, among legal fees, and he sued them for. I guess it qualifies as a permanent injunction to issue written notice to Swalwell when they're going to hold a rally, a political rally, or an organizing event of a certain amount of people that could impede the functions of the government. This is what he was suing for. Trump, a month ago, filed a motion to dismiss on the basis of presidential immunity. Unless I'm mistaken, no judgment rendered in that. In the meantime, Mo Brooks filed a motion to dismiss on the basis. Oh, no, sorry. He filed a request that the Justice Department take up his defense under the Westfall Act, which is the Federal Torts and Claims Act that governs federal torts committed by employees, where if the tort alleged was committed in the context of his employment, the Justice Department would assume his defense. He would no longer be a defendant. It would be the Justice Department. Justice Department says no in a 30-page memorandum, basically says it was a political speech, political rally, outside of your functions as a federal employee, so we're not covering you. Defend yourself, enjoy it. This frivolous suit, as far as I'm concerned, from the get-go. The question I had when asking you this, Robert, is I was drawing it back, and I'm trying to think of other examples, recent or that people would know. When was the last prominent example where the Justice Department said, okay, we're taking up the defense of the accused, and the accused is off the hook, and we'll step in? What was the last case anyone might remember?
I mean, they almost always do that. And so there are two different sources here. He could either have the Justice Department defend him and replace him under the Westfall Act, and they replace him with the United States government. That's one option. The other option was for the House of Representatives or the Congress to assign its counsel or hire outside counsel to defend him under the same grounds. Now, my own view is I agree with the Justice Department that this does not fall under the Westfall Act. And I agree with the House, the Congress, saying it doesn't fall within his congressional duties for congressional immunity for their defense of him either. But this is completely hypocritical. So these are the same bodies. So, for example, at different levels, I dealt with the Westfall Act in detail for the Covington boys and suing Senator Warren and now Interior Secretary, then Congresswoman Deborah Haaland. During that time period, they never requested that the Trump Department of Justice formally replace them. They requested it on their own separate terms, but they did have congressional lawyers defend them. But of note, the Justice Department never said what they could have and should have said, which is, oh, this is outside the scope of employment. Here's the big problem. The Justice Department has now just said that political speeches outside of Congress are not within the scope of your duties. Well, why did the courts then say that somebody putting a tweet out about kids in some other place is within their congressional duties, including the current Biden Secretary of the Interior and Senator Elizabeth Warren? Which is it? Now, I was curious whether the press would cover this with any degree of fairness or objectivity or would mention this. And instead, what they put in there is they said the Department of Justice defending Trump on libel charges from before, and they just said because of some other libel case history. And I was like, so they won't even talk about what that other libel case history is, which is the Trump Department of Justice cited the Warren and Haaland decisions as reasons why they had to defend Trump against libel under the Westfall Act. But there's different immunity for the president than there is for members of Congress. It's supposed to be broader for the president, less for the members of Congress. So what was amazing is all the legal and political discussions celebrating this was by people who also celebrated Senator Warren not being held responsible and Congresswoman Haaland not being held responsible, now Interior Secretary Haaland, even though what they did was clearly far out more removed from their duties of Congress than what Mo Brooks did.
Well, even let's just say it's equal. Let's just say it's equal so that we avoid, partisan accusations. Haaland and Warren, did the Justice Department take up their defense, or was it dismissed against them under the Westfall Act for a different reason?
Oh, it was dismissed under the Westfall Act for the same reasons. They just used Congress's paid lawyers, as my understanding, rather than use the Justice Department's lawyers. So that was the only distinction. And the reason was in the libel defamation context, that's not a recognized tort against the United States. So it would automatically be dismissed anyway. So that was the only distinction, is this tort is different than that tort, but it's the same core thing. It's amazing for the Justice Department to now. Why didn't the Trump Justice Department say that during the Covington boys case? Shows how useless Trump's own Justice Department was. But putting that aside, the logic is identical. Because they're saying if you make a speech for political purposes outside of the halls of Congress, not within the scope of your duties for the Westfall Act. Well, that directly rebuts what happened in the Warren and Howland cases, and in fact, in every other predecessor case.
No, but you're going to get into such a level of minutia of detail that they're going to wiggle out of their hypocrisy. They're going to say, yes, Elizabeth Warren, when she tweeted it, it was a matter of national concern, electoral. It was a matter of national concern about the wall. I mean, that's what they said. It had to do with the wall.
How is it any different? Clearly, Mo Brooks' speech was about matters of national concern. Their view is what matters is where you made. They took my argument from Warren and Howland, my cert petition that they chose not to get involved in, and they replicated it because now the target is a Republican they don't like. But I mean, I like the law. The law is right. The Westfall Act shouldn't apply outside the halls of Congress for a member of Congress. But the Justice Department was pretending, and a lot of legal commentators were pretending that this wasn't a complete reversal of the position the Justice Department has had for 20 years, really more than 30 years since the Westfall Act was passed. Ted Kennedy, who was initially sued, he made his statements at a political fundraiser outside of the halls of Senate. And yet the Justice Department said that was immune from speech. And it was the only difference between this case and those other cases is that these are this is a disliked Republican, and almost every other major case involved a politically protected Democrat. That's it. The Justice Department, after 30 years, has completely reversed course on what constitutes the scope of duties under the Westfall Act. And the only explanation that I can see is politics. Now, I think they're right now, and they were wrong before, but it was an extraordinary reversal. Let's see if they'll hold this up consistently. Will they do this the next time Maxine Waters is facing a libel suit? Some of these other people are facing libel. Are they going to take the same position, or will they suddenly do something different? For example, this may be a good bridge. Into the libel suit brought by for the impeachment trial, they've brought it currently just against the discovery company, Doar, which I'm familiar with from back in the day, because that company helped facilitate that fake tweet that they used in the impeachment hearings.
Okay, hold on.
And maybe could she expand to add the congressman for statements they made outside the halls of Congress, or will the Justice Department suddenly reverse itself again on what the Westfall Act covers?
Well, that's the amazing thing is no one's going to accuse you or me of political hypocrisy or opportunism because, yeah, we had been saying from the beginning what Elizabeth Warren and Deborah Haaland tweeted was not in any meaningful sense within their functions and should not be. And what Mo Brooks did follows the same logic. Let him get sued. I think the suit is frivolous. I think alleging that Mo Brooks, alleging what Mo Brooks said was inciting a riot is garbage. Alleging what Elizabeth Warren and Deborah Haaland said was defamatory, in my opinion, is respectfully true. But to say that the Department of Justice should defend either of them, I'd say no. These are things they took the risk of saying them. It wasn't part of their job. They might have been doing it to please their constituency, but it was definitely not part of their functions. And they went out on a limb, and they should have to defend themselves. Fine. But it is just an unequal balance. Like this is the arms of justice just tilting to the left into the saying Elizabeth Warren and Deborah Haaland. The suit gets dismissed for sovereign immunity because they were in their functions of employees, federal employees. But Mo Brooks has to pay his own lawyers. Now, the suit continues. They don't take up his defense. He has to defend himself at his own cost and in an unfavorable jurisdiction. So they'll dismiss this on the merits, but not after a long, lengthy, costly fight. And that's the two-tiered system that politics destroys. I didn't flesh it out in this detail in my video today, but yeah, I think if Mo Brooks incited a riot, he should have to defend himself. I don't think he did, but Elizabeth Warren, these are analogous in the sense of they were both outside the scope of their employment. One gets dismissed, the other one has to go defend himself at his own cost.
Exactly. And there may be forthcoming legislative proposals from Congressman Thomas Massey and from Senate candidate J.D. Vance to make it clear that the Westfall Act doesn't apply beyond the limits of the Speech and Immunities Clause of the U.S. Constitution, which is where it was until 1989. Until 1989, you as a member of Congress could be sued for your statements that were not protected by the Speech and Immunities Clause, such as statements made outside the halls of Congress that didn't have a close nexus to activities within Congress. Your traditional scope of duties kind of analysis. It was only after 1989, when mostly Democrats were being sued, that courts and the Justice Department rushed into their defense and dramatically expanded the Westfall Act to mean something it legislatively was never intended to mean. And it's good that they've suddenly reversed, but we'll see if they'll be politically consistent about this, or this was just, hey, two sets of rules for two different classes of people.
All right, excellent. All right, with that said, let's move on to another one. It's a totally separate thought. It's just the one that came up in my head. The Scarlett Johansson suing Disney, which it's a phenomenally interesting lawsuit. I'll get into I'll summarize the details. I will explain what I might have missed in my video. Scarlett Johansson, blockbuster actress, starring in Marvel's Black Widow. Marvel is now owned by Disney because Disney bought Marvel. The contract between, let's just simplify and assume that this is what the contract said, that Scarlett Johansson's remuneration is based in part on box office receipts. There's an industry standard where that box office exclusivity lasts between, let's just say, 85 and 130 days. Disney buys out Marvel 3 or 4 years ago. In the meantime, Disney launches its streaming service, Disney Plus, where they offer exclusive stuff to Disney. Some of the things are Mulan. A similar thing happened with Mulan, actually, and Black Widow. And they simultaneously, instead of giving box office exclusivity, box office receipts, only releasing in the box office, they simultaneously release Black Widow on Disney Plus. What I missed in my video is that not only do they do this for $7 or $8 subscriber fees for their users, they charged a premium to their users, $30, to get to watch Black Widow early. From all we can see, Robert, and you'll correct me if I'm wrong, none of that $30 surcharge for Disney Plus went to Scarlett Johansson. So what they effectively did was take Scarlett Johansson plugging the movie for the box office release and then turn around, cannibalize the box office sales, and use Scarlett Johansson as effectively to promote Disney Plus, where they simultaneously stream it. Am I missing anything in terms of the facts there?
No, and the only other sort of pertinent facts are the box office numbers were bad. In my view, because they decided to make it a woke Me Too movie, hired a woke director, a woke writer, who didn't know what they were doing, wasn't up to the Marvel history, antagonized core parts of the audience with some of their own marketing campaign. And that sort of, but neither one of them can claim that's the reason for the money being so low. Scarlett can't, Johansson can't because she was on board with all that, and Disney can't because they're taking Marvel's properties just like they're taking other, Star Wars properties and retconning it for woke politicized purposes. It's sort of Mickey Mouse on a lefty version of meth or something. So the net effect of it is you get these, it enraged a lot of people in the comic community and the community that follows movies that were part of the core audience. But that they can't really talk about. What they can talk about is whether the distribution method caused a large drop. My understanding is that she had a 5% of gross receipts at the box office percentage. And traditionally, that translates in a Marvel movie to $1 billion global box office. That was that was a reasonable number to think could happen. And so she was looking at 50 million bonus on top of the 20 million apparently she was already paid. So there are three major issues with what's happening. One is this is a big war going on. This goes all the way back to the Screen Actors Guild strike a decade or so ago. They started to see that the whole old economy of movies and TVs was shifting to a digital world. And they realized the studios were going to use that to strip them of their royalties, to strip them of their bonuses, to strip them of their back-end cash. And that was one of the reasons for the ferocity of that strike. Now, it only partially resolved the issues. A lot of these issues were still unresolved. Here, Disney, there are three problems that Johansson has identified in her suit people are confused because in Hollywood, as an actor, you use what's called a loan-out company.
Yeah. So actually, explain that. I was going to try to explain it, but I know that I know that people would know that I didn't exactly understand what a loan-out company was. I think I understand, but Robert, you know better. What is a loan-out? Periwinkle Entertainment Inc. was the plaintiff in the suit, called her loan-out company. Who owns that? Is she the owner? And what does it do?
Technically, a loan-out company is just a device they've used in Hollywood. It's the means by which you, as an actor, sign your talent with a studio. That's the short version of it. And the loan-out company loans out your labor to them, and it has all of these tax and other asset protection advantages and economic advantages tied to it, and it's a judicially approved one, so it's why they all do it. It's interesting, by the way. All these lefties that preach all kinds of lefty politics in Hollywood. Look at how they handle their own money and assets.
Well, does she own the shares in the loan out, or is it an agency basically?
Oh no, she owns that. That the agency gets a percentage. Now that is part of why this suit is happening and why it's so big in Hollywood, because everybody's getting a piece of this. So that 50 million bonus, probably 5 million would go to the agency, another couple of million to some lawyers, to accountants, to managers, so everybody was ticked off when Disney did what it did, because a lot of people have fingers in that pie. And so that's at one level what's going on. The second level what's going on, the one is just the big backdrop of digital restructures the financial economics of Hollywood, and the studios are trying to do it in the big companies to screw over their labor providers, the people who you're actually interested in watching, because it's not like you're there to watch Mickey Mouse, the company. But the second is the streaming services is something Disney has entered into aggressively, and there's a big open debate as to whether any of them can survive or whether they just end up cannibalizing each other. So the Netflix was highly successful. They were the first big entry, but otherwise Netflix was highly successful because they were the only game in town. What happens when you have a dozen streaming services?
It turns into YouTube channels where you just end up spreading your time around, but who's going to pay for 5, 10, 15, 20? So it's sort of the locals problem, is that you have too many people that you want to support. At some point, you got to pick and choose, and you'll stick to a couple. But if there's too many of them, you're not going to be spending Disney, Netflix, Hulu. I don't know if Hulu's paying for, but what?
Yeah, no, Hulu, Amazon Prime, ESPN, HBO Max.
You're going to be spending more than you ever spent on television. So it's like it'll turn into the replacement. Yeah, but so fair point. They're going to cannibalize each other and kill off each other to the point where I don't know how they make money.
Right now is the critical time period, because they've all launched within the last year or two in terms of real aggressivity. So Disney was and here's the third aspect to all of this, is that Disney CEOs make all their money based on stock price. And this is a broader problem in the American economy, that we've divorced corporate executives from, long-term profitability, good treatment of workers, making good, safe products. That's not your motivation if you're a CEO. It's what's my stock value next quarter. And in particular here, they probably had reason to know that this film, all of their other Star Wars films and other woke films have underperformed. So they should have known that this woke film was going to underperform. But the question, and that's part of their argument, is they agreed to a wide theatrical release. And the point of that was, part of their argument is there's two other reasons not to put it on the streaming service. One is cannibalizing the box office, just the people who buy it on the streaming service. The second is the ability to pirate the film once it's digitally released like that, which is much easier to do and is much more popular for pirated communities than is somebody filming it off of the big screen. And then the third aspect is they're trying to build up the timing to do this in the middle of a pandemic, when they didn't have, or at least the latter stages of it, when they didn't have approval from China. So her point is, if you had waited to release this to a different, put it this way, it's that their view is, Johansson's view is, Disney would have waited to release this but for their desire to boost Disney Plus, which was key to their temporary stock value. And so that's why, and even though it meant a bunch of stuff was going to be pirated, even though it meant it was going to have less theatrical interest than if they just delayed it another year, even if it meant they waited until they got China approval to release the film there, even if it was worth it to them because they were going to get to line their pockets, and they got an added bonus. They don't have to pay Scarlett Johansson. Every penny of that streaming money comes to their pockets. None of it goes to the box offices. None of it goes to ScarJo.
And just the shameless projection accusation of others that they're accusing Scarlett of exploiting. What did she say? Being callous. The horrifying.
She had the woman famous actress card, and they came back and said, no, we have the COVID card.
A lot of people in the chat are taking great satisfaction in the left eating the left. Some are saying, look, she made 50 million. That's obscene, whatever. At the end of the day, I like one of the chats I brought up. Doesn't matter if she was entitled to $50 or 50 million. Disney is trying to screw her. And the question I have at the end of the day is, it's going to be based on the evidence. How strong is her contract to justify this claim? To me, it seems pretty obvious. They had the claim for box office. It didn't say exclusivity, but it said theatrical release. We all understood what that meant. There were some emails clarifying it back and forth. At the end of the day, was it a ironclad 5-page document all in one? No, there was confirmation emails back and forth. I think the evidence is pretty clear, Robert. Is the evidence pretty clear in your mind?
Yeah, because of the Disney email saying we recognize we will have to renegotiate this if we don't do an exclusive theatrical release. And then the bigger problem for Disney, because the other thing she's pointing out is it's not just how much money they made on the $30 premium fee, it's how many subscribers did they get because of this? How many subscribers did they keep because of this? And how much are they even being competitive in the streaming services? And what Disney was looking at is, we need to get to a certain point before Hulu and HBO Max and Netflix and we're catching up to Netflix and everybody else gets to. Otherwise, we may lose. That we have to win this war within the next year or two, or maybe Disney streaming is a failure. And so that's why they were willing to take this gamble. But there's no doubt they knew what they were doing. They wouldn't even have conversations with her building up to the release. She kept her contractual obligations to promote the film, so she put herself in the best position. But again, the film being bad is her own fault, though.
Well, I haven't seen it. I haven't read Nerdrotic or Doomcock's review. I haven't seen Nerdrotic or Doomcock's review. I can only imagine because everything's going the same way these days. But
Critical Drinker has a really good review. As does Geeks and Gamers and the Quartering. All of them are just and Baby versus Heel Face or I never get that right, but he's a funny guy. He had a review on it too. But it was getting low popular reviews amongst the public in terms of the consumer side of the equation. That's like the lingering background is that because of wokeism, Hollywood is losing money. And so the studios are trying to steal from every place they can to cover up for that and to prop up their stock value. When the real reality is if they just weren't being woke filmmakers, everybody would be happy and sharing in the cash. But because they're typical woke thieves, when the money gets tight, they're going to steal from each other. And that's what. But I think Johansson's claim, and the bigger problem for Disney, aside from the PR disaster this is they've done this to several films, and apparently a bunch of big actors and actresses who had the same theatrical release language in their contract, because it's been pretty standard for any substantial actor for the last 30 years to include the back end profits. But they had so many creative accounting ways to steal from actors. I mean, I dealt with this from Wes and Blade and some other contexts. They are creative at hiding money and pretending. Hollywood once pretended that Forrest Gump lost money just to screw over some people. So that they've always been this way. They're the biggest thieves in the room, and they're the biggest wokester promoters, and they just don't want to pay the economic price for their wokester promotism when these films fail. Instead, they want to steal from the actors and the actual talent. And I think he should win, and I think it's going to unleash a bunch more suits coming down the pipeline.
Yes, someone said it's going to settle out of court. It might very well, but this type of secret is not going to remain too secret in Hollywood for very long. It's
there's already two prominent actresses considering bringing suit already, so they're waiting to watch. The one I forget, Cruella, I think that actress is. I think it's Emma Stone, I believe, was in that. It may also be the case for that new Jungle Cruise, whatever. There may be similar issues there because HBO Max had this same problem because of their tie into Warner Brothers and Universal, and they just paid everybody off. Disney said, "Screw you, we're just going to take all the cash and run." Yeah, it turns out Mickey Mouse from South Park, that may be the real Disney.
Well, some people were making jokes that Mickey Mouse has a rat's tail, but it doesn't make Disney look good. It makes it look very bad. Other people are saying, look, all they have to do to right this wrong is to pay her the equivalence from the $30 premium they charged for Black Widow. But bottom line,
no, she's claiming more damages than that. She's saying the timing of the release was a problem. She's saying that her claim is for $50 million is my guess of that's what the rumor is. And my guess, she's saying that's what I would have made, but for what you did. And even their own reporting said 60 million is what they made on premium. So she's saying, give me all of that, and then maybe I'll go home. And that's only going to be the first one. There'll be more coming.
No, give me all that. But then meanwhile, Disney still makes the subscriber base that they gained off of her work, but for they wouldn't have gotten it, or they might have gotten it a little later. It's a good lawsuit. I mean, it looks dirty. I didn't think there was anything missing in terms of the evidence. Yes, it's an email exchange, but that's still good. I made the joke.
You saw that when Disney's reaction was to out how much she'd already made. That was kind of, oh, you've already made 20 million on this, and to play the COVID card. That said, they don't have a legal defense. They were just playing in the court of public opinion.
Yeah, the COVID card was what pushed. Someone says, Viva, you came in with your mind made up. Yeah, when I read the COVID card was being played, I knew that dishonesty was afoot, and there was nothing going to change my mind about that, unless the evidence is not there, but the evidence seems to be there. Okay, fascinating. We'll see where it goes. Let's do another one, talking about big tech giants that people hate. Facebook's lawsuit or getting spanked out of Germany. Now, I'm putting that in quotes because I think something is going on here that I don't understand, but I have my suspicions about. Facebook, coming out of Germany, lost a lawsuit, or the court basically said Facebook cannot have terms of service that provide for termination of accounts and deleting of posts without notifying the users, providing an appeal process, and giving some, I guess, due process, for lack of a better word, to users. So that was what I understood the judgment to be in a nutshell. Where I start to have my questions as to whether or not this is actually a concerted effort by big tech and the courts. Germany has recently enacted some of the toughest hate speech laws in the world. Things that would shock Americans, but that might even surprise Canadians in terms of what they consider to be hate speech online, it being outlawed, it granting very, very big powers to big tech when it comes to hate speech and the government. So part of me says, okay, the German courts come and say, Facebook, you can't delete the posts and block the accounts without giving them fair warning. Part of me reads into this as saying, the courts are basically saying to Facebook, you've got to notify the government as to who the account is. Basically, if it's an anonymous account, identify the user to the government so the government can deal with the hate speech stuff in accordance with their laws. And so it looks to me that this loss for Facebook is only going to turn into a net positive because they're going to amend their terms of service, but they're also basically going to, as a matter of default, potentially, out anonymous accounts that they have determined contain hate speech, given the hate speech laws in Germany. Am I now reading too much into things, and did I mischaracterize the decision itself?
No, I mean, I think there was where Germany and Europe will not be good is on protecting free speech. Where they will be good on big tech is in three areas. One is privacy. Second is monopoly and antitrust. And the third is due process. And so the thing with big tech is they're not only widely surveilling and censoring people, those two aspects Europe doesn't care about. What Europe does care about is the other things that they're doing problematic, which is denying people any due process. And their argument was our terms of service allow us to do it. And in Europe, they don't have the same deference to corporate contracts we do in the United States. And I think for good cause, frankly. I think the unequal bargaining power in the United States means we have to reevaluate how much we defer to the power of contract. Are we deferring really to the power of contract, or are we deferring to the power of corporations and big institutional actors? And we used to have some law that limited that, but that law has been undermined in the last decade or so. But what's good here is Europe. Also, I think in the same week, Germany whacked them a bunch of money for monopoly violations. So where they're good, where big tech is going to be hemmed in by Europe is in the privacy context, in the monopoly context. And this was a critical ruling. It's the first ruling I know about. It's an argument that I've made in other contexts, but that basically there should always be some form of due process applicable before they suspend somebody's account under certain, I had it under unjust enrichment and other equitable grounds. Germany took their own law and applied it in their context. But it was a big ruling because it means that all the big tech people are going to have to start respecting privacy, not going to have the monopolistic power they want based on the other ruling, and they're going to have limitations of due process and how they deal with people. And the hope here is that if they're doing it throughout Europe, why not just apply it around the world? Just apply a global standard that you don't suspend people without any notice and without any opportunity to be heard. Because a lot of people that would reverse if they actually had due process in place. I mean, we've seen it multiple times. Alison Morrow, who had a very good interview with some January 6th defendants that people can see on her Locals and YouTube channel.
Everyone should check that out. Alison Morrow on Locals, Alison Morrow on YouTube with the two attorneys for some of the defendants. Amazing stuff.
And then also, and she had a good discussion with an interesting candidate for the Canadian Parliament also last week.
That was a daytime stream. It was great. I don't know what is it called, Rothkin or Shark? Oh God, Rockfin is the name. So she goes from YouTube to Rockfin. I always find that going from YouTube and going to another platform doesn't work that well. But there were certain things that we were discussing which could get her into trouble on YouTube, which might be an incentive to go watch it for anybody who didn't see the second half of that stream. But yeah, it was a fun discussion. It was yesterday. Feels like a week ago already.
Exactly.
But someone said
it was a good ruling for those reasons.
Well, but someone said that the German courts don't like. What did they say? German courts don't like someone. The private companies taking power away from the government. This to me just reads like, okay, we want big tech to work hand in hand with government when it comes to hate speech, not about any due process in a meaningful sense. That's the way I read it. That's the way I fear for it.
Well, I think, but no, both are present because they didn't need to go through the due process. It's natural to Europe. Europe has Europe has never had deference to contract the same way the U.S. has. And so it's one area where big tech could be hemmed in. Europe's more aggressive about dealing with antitrust than the United States has been in recent decades. And they're honestly better about privacy. So it was a good due process ruling, and hopefully they'll start applying it here so people just won't suddenly lose it. They'll have a chance to make an argument, a chance to present their case. Because what we've seen is that when big tech actually applies due process, a lot of people get reinstated because it wasn't a violation of their rules. So the goal is to at least hem in big tech somewhat, and this decision is something that can be cited hopefully outside of Germany and changes some policies and procedures. And you see, as a bridge into the next big tech case, the need for it in the privacy context, because a school had to sue YouTube because YouTube was publishing videos about their minor children while they're in school that was not done with those children's consent or their parents' consent or the school's consent.
Yeah, so
and despite multiple requests that they take it down, they had refused. They forced a lawsuit instead.
Okay, so explain the details of this one. I'm more or less familiar with this, but how did the videos end up online? Who shot the videos? Who asked for them to be removed? On what account were they being broadcast? And then what ended up? I mean, what's the status of it right now?
So basically, someone had shot a video, I believe, for a rap video, is what my understanding, that with students on a playground and other students making postures. It's not clear how that video was made, but it ended up on YouTube, caused controversy because of how the kids were being portrayed and perceived. One can guess what some of those issues were. Cuties kind of issues would be my guess. But so the parents complained that to the school and the parents then complained to YouTube, and they said, look, this video was shot on school grounds without school authorization, using the visual images of minor children without either the school's or the parents' consent. This is something you must take down under privacy rules. And YouTube refused. And so the school district has had to file suit. That's where it currently stands. They had to file suit to try to get YouTube to take it down and to seek some remedy for it. But it shows YouTube's complete lack of respect for privacy outside of certain politicized contexts.
Well, but the YouTube's defense is going to be that the uploader presumably stated they had the right to upload the video. So I don't want to get involved in it. Sue the uploader, sue him for damages or sue him for whatever, to get a judgment that then says YouTube has to take it down. Is YouTube fighting it, or is YouTube just sort of?
Oh, yeah, YouTube's fighting it so much that's why the school district sued them. That YouTube refused to do anything, refused to take any remedial or corrective action at all. And my understanding is it still violated what YouTube publicly promises in terms of privacy of minor children information that shows up. This is like the Twitter suit, where the Twitter left up CP, even though there was constant complaints and they knew about it for whatever reason. And people can go back and watch the sidebar with Eliza Blue about more discussion about that case. But there's still limitations on what they can do, particularly if it involves filming that takes place on school grounds involving minor children. And YouTube's refusal to do so is interesting, especially given how eager they are to, if some big company says something about a copyright or somebody complains politically, they're eager to take it down. But when there's an actual violation of real rules, of real principles, they seem to be slow to take it down.
Yeah, the only reason I can be somewhat sympathetic to YouTube is that you can run into the realm of context where someone does in fact sign a waiver. The parents sign the waiver, but then someone says, no, I don't like the video anymore. I want you to take it down. And then YouTube can't get in the way of a civil dispute between the creator and the purported moral rights holder. And they say, look, we can't deal with any of this. You guys figure it out and we'll abide by a court ruling if we're named. But yeah, but then there's another part of it that says YouTube has just gotten to be so big. There are no humans anymore at this enterprise. Try to ask a robot to do something and they don't do anything. So go to court, get a judgment. You might get a judgment by default. YouTube will say we never got served and it'll be years and years down the line. The video is going to be up there. All the damage will be done and there will be no way of remedying the wrong. But yeah, I could just see there being a context in which someone says, I no longer like the video. Now I'm going to say that you don't have my permission to keep it up. And I ask you to take it down. There's a dispute. And then YouTube says, what do I do? And what do they do at the end of the day? Just take it down because of objects?
I mean, here, someone referenced COPA. I think COPA is still in force.
Yep.
And it's one of the issues involved in the case. Here, because of these were minor children on a school ground, this should have been an easy takedown request. In terms of what they claim their policies and procedures are to be compliant, and they just weren't. And what I think it shows is probably means is the AI really running a lot of these places is perv.
Yeah, no, and now just to go back and be the realistic lawyer about this, oftentimes all you have to do is show the releases on any video licensing agency. When you have a minor, when you have someone who is not your kid, just say, show me the release, and then we can sell the video, we can keep it up. YouTube might have gotten too big to deal with these types of problems, and it's leading to problems. But yeah, very interesting. So, anyways, we'll see where that goes. Those are lawsuits that some people, they don't have the glamour of the political stuff, of the the big issues of the day, but these are real problems that people are dealing with on YouTube.
Yeah, Robert, no doubt. And hopefully they start to hem in these big tech abuses.
Yeah, well, I mean, if Europe is good for one thing in terms of internet, it's privacy laws and privacy invasions. That's one thing where Europe is maybe ahead of the curve as relates to Canada and the US. But this is on one of those issues where you're dealing with kids who get put up online and you can't get the images down. A different level of egregiousness compared to the Twitter stuff, but nonetheless. Okay, what do we segue into here, Robert?
To the people that Allison Morrow interviewed as someone who was previously subject to wrongful big tech censorship on the January 6th defendants case. Not a big update, but it's fascinating. So according to the government, they just cannot produce the relevant discovery, even for imprisoned defendants, until 2022. And luckily, a judge finally pushed back a little bit against that this past week, saying that no, he was not going to waive speedy trial rights. He was going to require the trial to go forward in November, and they just better find a way to produce the discovery. All of this is a product of the arrest first, investigate later choice that the Justice Department made under Biden's administration. Very unusual way. Normally, you would spend a year and a half, however much time you would need to gather all the evidence to find out all the facts, and then you go out and indict people if they've committed a crime that's worthy of federal prosecutorial resources. Here, instead, they just, let's go and arrest a bunch of people. Let's lock them up. And then let's look and investigate and figure out what actually happened. And so fortunately, that judge pushed back some. There's some good defense lawyers. Like I said, Allison Morrow interviewed one of them today, actually, that's on her channel, and that are pushing back on all of this. It turns out a lot of narratives that have been pushed and pitched about January 6th defendants are increasingly unraveling. And the question that, and then of course also this week you had the Congress members who tried to look at the prison and weren't allowed to go into where they're being detained. And they could have gone through certain formalities, but they should have. This is the U.S. Marshals. These are pretrial detainees. These are not people who have been convicted of any crime at all, and yet it's indistinguishable from a gulag. And so from a regular hardcore prison, and the way they're being treated is just outrageous. Yep. And so they're willing, the fact they're trying to hold back all the discovery and documents raises it clearly indicts the way in which they went about this process. But it also raises questions. What's in there that they're so scared that they just don't turn it all over? Well, they can turn all of it over.
I said this before. It's not my insight, so I can't steal it. Karen Strahan, for anybody who doesn't know, she comments a lot. She's active in the channel. One of the comments she posted on this was, how many thousands of hours? There's thousands of hours of video footage. They've released
14,000.
14,000. They've released 5 minutes, maybe. Let's just say they released an hour of the montage that they played in Trump's second impeachment. And everyone's saying, why can't they just release all the video footage? Well, one theory, and it's a theory, it's a damn good one, is that the prosecution hasn't been able to go through all of it in order to determine what the collective knowledge of the internet and the 4chans and the 8chans and the Reddits and what the subreddits, what they're going to be able to determine, because the guy who accosted or who confronted Tucker Carlson at a fly fishing shop, 5 minutes, the internet figured out that he had connections to intelligence. So Lord knows they dumped this information out there. You're going to see a lot of evidence, a lot of stuff that is going to be not just bad for the prosecution and good for the defense, bad for the United States and bad for the process of law. And they don't want to let the aggregate knowledge of the internet dissect that and determine that on their own, because it'll make them look terrible in a way that will discredit the system in a way that might be irreparable if we haven't already gotten there.
And that's probably why they accelerated those hearings, Pelosi's show hearings, with these crying cops that, were doing their whole, they thought the world was about they did their AOC impression. AOC also, Project Veritas, I think some other people outed, I think it was Project Veritas, outed this week that AOC had made up other stories to CNN that even CNN was so embarrassed by, they tried to bury and hide that part of the interview. So you had that come out. You had these cops doing this cry routine with this fake narrative they thought the world was ending. I mean, just sad, pitiful. Yeah. You had another federal judge in one of these January 6 cases start doing another one of his shaking routines because the defendant wasn't wearing a mask. I mean, this is the mindset of the legal system in D.C. that doesn't realize that to the rest of the world so much that countries like Russia and Putin can make fun of us for our political targeting, our politicized prosecution, our abuse of people in custody for politicized purposes, that we're the laughingstock. And the D.C. legal system is still so far out of touch with that political reality that the prosecutors are trying to play every game they possibly can to avoid full public transparency and full public exposure. So hopefully they'll continue with their motions for discovery, continue with their demands for speedy trial enforcement, continue with their demands for release pending trial. Because what people also don't know is the right to bail, your right to bail increases the longer you're detained. And increasingly, the only reason these people are being detained is because the prosecution can't put their evidence together and give it over to them.
Yeah, I find it shocking. I don't say this with any political inkling. I find it shocking that anybody can say they deserve to be imprisoned. People say that in a manner that presupposes or that takes for granted they've already been convicted. These people haven't been convicted of anything. And it's not to say that anyone who's not been convicted should be released willy-nilly. Depending on the severity of what you've been accused of, an argument for pretrial detention makes a little more sense. Risk of violent recurrence or whatever. There's a lot of circumstances where I can understand pretrial detention for the safety of the victims or the general public. Not here. And I'm saying this, I've seen what happened from day one, Robert, when we did our live stream the day of. Nothing here can justify this level of detention, period, full stop. Call me partisan for saying it. I don't care. Nothing that happened that day can possibly justify this. When, by comparison, you have the FBI agent in the Whitmer case who was released on $10,000 bail personal recognizance for being accused of causing severe bodily harm less than murder, something along those lines, in a domestic abuse accusation. Let out on $10,000 bond, personal recognizance. Other, not to compare it again, other people being released or having the charges dropped entirely with prejudice. Nothing can justify it. And when people say, yeah, well, they did something stupid. Okay, you get convicted and you go to jail for 8 months, fine, for doing something stupid like the one guy. You don't get pretrial detained without bail. It's cruel and unusual punishment without any qualification, period, given the accusations, even assuming they are found guilty, even assuming they're convicted, it's unjustifiable. But we're dealing with a poisoned, I don't say poisoned well, that has a connotation, but we're dealing with an environment where people will rationalize injustices because it's politically convenient.
No doubt. And speaking of politically problematic prosecutions, this week they also indicted the ex-CEO of Nikola. I think it's Nikola. I mean, basically, it was a Tesla imitation company, and they just took the first name of Tesla, Nikola. But they indicted him. What was interesting is what they indicted him on, as George Gammon made note, almost all of the substantive allegations where they're alleging securities fraud and other fraud read like you could substitute that CEO's name. I think it's Trevor Milton, former CEO. He's now a billionaire. So he'll be able to mount a defense. But you could say the same things about Elon Musk. Because I thought they were going to have something really specific, really particular in the indictment to separate this from a lot of other people who could be indicted for just being for bragging. But it turns out it's about how he was promising a truck, but they really weren't ready to do the truck. And he was promising a semi truck and they weren't really ready to do the semi truck. And he was promising this breakthrough and that hadn't happened yet and wasn't likely to happen. It's like, well, that's a lot of the people who have problems with Elon Musk say that stuff about him. So it's the only advantage for Elon is a little more political capital, and his business hasn't gone down. Whereas, Nikola's great sin was that it didn't work. The stock market went down ultimately on his company. So, but it raises interesting questions. Are they going to start saying that sales tactics? Because usually it's very specific. A securities fraud allegation is usually they said this specific factual thing, and this fact was clearly not true and it was really impactful. Not the kind of things we're used to seeing, at least people like Elon Musk do on a regular basis. I'm going to have this. I'm going to do this. I'm going to go to there. What most people know is Donald Trump kind of bragging.
Well, we're talking like material fraud, falsifying documents, concealing relevant information versus in Quebec, we call it bon dol. Bon dol, which is bon, good, dol, which is fraud. It's called good fraud, like a used car salesman says, yeah, it's the best car we have. Nobody assumes that he actually means it's literally the best car that he has. It's sort of like the Rachel Maddow defense of sales, or the Tucker Carlson, if I want to be politically fair.
Or Donald Trump. I mean, Trump is infamous. Trump's always bragging. But now they're going to start saying that your bragging can be the subject of a federal criminal indictment if you're no longer politically protected. And that's what I found about that indictment kind of problematic. Because there are a lot of people who had been correctly critical of that company and a lot of this promotion of electric cars and how it was being oversold, or at least and then the rest. But to criminalize that life in prison kind of crime is what that he effectively been. That's a different animal.
It's the same thing, and mutatis mutandis that we're seeing with Trump's associates. You're indicting people on tax fraud that ordinarily would get a reassessment with penalties and interest, not 15 years in jail, but for the fact that.
Well, speaking of which, that's a good bridge to the Trump associates who are now getting criminally prosecuted. It's clear they're being targeted, and he was only released on $250 million bail. But I think it's the highest bail ever, at least the one that I know of. Maybe somebody else has been stuck on something else, but it's insane.
What was the individual accused of?
Basically what they do in Washington, D.C. every single day. So what he's accused of is, secretly lobbying for the United Arab Emirates, apparently. But again, this is, all those rules. No, that's what everybody in D.C. does. You could take a rock and throw it at somebody in D.C. and hit him with worse crimes than what they've charged him with. Yet they're trying to lock him up for life. and put ridiculous bail terms on them. And clearly it's an attempt to go after anybody connected to Trump that they see as powerful or influential, just continuing it. What they started back with Manafort and Stone and Spygate and Russiagate and the impeachments, they're now continuing not only with the January 6th defendants. Julie Kelly had a good piece in American Greatness about how this is one extension of the same thing. Starts out saying he's working for the Russians, and now literally everybody that supports Trump is maybe a domestic terrorist we got to keep an eye on. And anybody connected to Trump is being put under a microscopic inquiry and a macroscopic review of their of anything they've ever done. And they're criminalizing things that are basically custom and practice in D.C. But it's not a good sign when the judges are requiring ridiculous bails, and it's likely a sign of a judiciary that's going to be hostile to the defendant because, frankly, of his politics.
I'm going to ask what the individual is worth. Like, I mean, not that $250 million is not a lot, even to Jeff Bezos. What's the individual worth?
I don't know. I mean, I believe he may be a billionaire.
Yeah. And that's not
like a billionaire typically doesn't have $250 million cash sitting around. They're usually not all that liquid.
He'll just have to, I don't know, pledge some buildings or real estate. I don't know what this says, so if it says something bad, I apologize. Topic for the end, if you have time. Robert, what do you think of the idea of American populists should insist on playing? What do you think of the idea that American populists should insist on playing the full U.S. anthem at events, especially the fourth verse? In my 30s, and I just heard the full anthem for the first time this week.
Sure, I'm all for that. Though I still like some other songs better for the American anthem than our current one. Like when you hear like the French national anthem or the Russian national anthem, it just sounds better. The American, it's Star Spangled Banner is nice, but it's kind of choppy the way it's written. It's not doesn't have the same passion throughout the song that some other ones do. But I'd be all in favor of playing the whole song though.
Well, let's see what this says. If I can read this one out loud, I'm going to read it, and then we're going to say a reduced $300,000. Okay, July 15, 2021. Louisville,
just pointing out, people who shoot 3-year-olds get bail. But January 6th defendants can't, and some guy accused of just practicing normal behavior in Washington, D.C. has to post $250 million. Our legal system doesn't realize how disconnected it's getting in its perception in the ordinary populace by a large segment of the people.
I think too many people are just largely unaware of this, and if we're doing nothing else, Robert, it's sensitizing people to the realities of the judicial system and how it's being perversed. It's perverted by politics. But instantly, you mentioned it earlier, like you're talking about the January 6th and Russiagate. A funny one, Robert, that I just looked up because it came in the news, not even recently, but I keep messing up his name. Michael Flynn's partner, whose judgment that was vacated by the judge from the jury condemnation. His name was Bijan Rafikian. So this was Michael Flynn's business partner who was initially convicted by a jury of, I guess, FARA violations. The judge in that case overturned the jury conviction, said basically no reasonable jury, if they understand the law and the evidence, could convict. It was on appeal by 3 judges, overturned the overturning of the decision and basically reinstated the conviction against Rafikian and sent him back for sentencing. What I didn't know in the meantime, I'm just looking this up, that somebody was sentenced to 18 months in jail for threatening Judge Emmett Sullivan in the context of that file because they left a voicemail saying overt threats in the context of the pandemic. And there's a bunch of attenuating circumstances if you want to attenuate the threats and the frame of mind of the individual. But a whole thing had been, the never-ending Flynn saga. Not only did Rafikian, Flynn's partner, get his vacated judgment reinstated, somebody was sentenced to threatening Judge Emmett Sullivan. Emmett Sullivan said because of the threats, he had to change his lifestyle. That saga doesn't seem to be ending. But are you familiar with the reversal of the acquittal, basically?
Yes. And they're petitioning the U.S. Supreme Court to reconsider because it's an expansion and an extension of that law. Again, prior to all of this, I think there had been 6 Foreign Agents Registration Act prosecutions in history. It was almost never done outside of extraordinary circumstances or as a tag on. and they've weaponized it. This is the problem with so many federal criminal laws. I mean, you got federal criminal laws about where you can fish, when you can fish, how you catch the fish, what you do with the fish. I mean, it's preposterous, the number of federal criminal laws we already have. They should just we should scratch them all and start from scratch. Get rid of the FBI, start a whole new thing. Because these people have proven incapable of being able to do their job. Who would know that an organization created by J. Edgar Hoover was not trustworthy for future purposes?
Yeah. If anybody, I think everyone needs to. You did a hush hush on Hoover, right?
Yes, I did.
I'm trying to figure out why I know what I know, but everyone, if you're not already subscribed to vivabarneslaw.locals.com, if for nothing else, you get sneak peeks of the videos, you get some cute pictures of my dog, you get Robert's hush hushes, which is an encyclopedia of information jammed into your brain in 30 minutes or 20 minutes if you listen to it at 1.5. But, speaking of criminalizing everything, in Canada, they just amended the gun laws such that if you want to transport your firearm for the purposes of repairs even, you need to get permission from I forget what they call them, the chief firearms officer. You need to call someone to get permission to transport your weapon from point A to point B. More laws, less justice.
Well, speaking of guns, on the good news, there was good news this week. There's a bunch of city. I think it's actually as many. Somebody said as many as 60%, or maybe but a huge number of municipalities, cities, and counties and towns across the country have passed Second Amendment sanctuary status that will not allow their local government officials to enforce any restriction wherever it comes from that would violate the Second Amendment. And they clarify that in a local statute and regulation. I believe it's Columbia County in Oregon had passed one of those. And of course, all the big names, including the Attorney General for the state of Oregon, but Bloomberg in particular, who's the biggest gun control advocate in the world, spends billions in its favor, sent his lawyers in to try to overturn it, and they lost. And it was kind of funny how they lost, because it's it's a doctrine I don't believe in, but it's a doctrine that it deservedly applies to these kind of people who use it all the time to screw everyday people, which is the court said, you don't have any standing to bring this claim at this point. There's been no clear documented harm that you can substantiate. And so, but it was a good win. Gun Owners of America, other groups. So that was good to see on that side. Now, on the flip side, there was a big tax passport case. And so it has broader implications for Vaxports and everything else. It was up at the 10th Circuit. Hopefully they get to the U.S. Supreme Court. There may be subsequent challenges that I'll be involved in. But the Department of Treasury has a rule that if you are behind in your taxes at a certain time, they can revoke your passport. First, they can suspend your ability to apply for one or to get a replacement one, and then they can accelerate that to revoking it entirely. So the question was, could they do so constitutionally? Was there a right to a passport? Is there a right to international travel? The 10th Circuit split, and one of the justices noted that clearly there had to be a right to international travel, because he went through the whole long history, and he pointed out that the right to travel is fundamental to core constitutional liberty at its very basic. But the other two judges said no. And so so they not only allowed for that passport revocation to occur, and to give people an idea, in the past, the Supreme Court has even recognized you can't deny passports to people because of their political affiliation, such as communists, with the assumption that that was a fundamental right. So this court trying to step back on that, and I think even though they did it in the tax context, I think it was the broader Vax passport context some of those judges were thinking about. They want to take away your right to travel internationally. They said the Privileges and Immunities Clause only applied to interstate travel. There's some truth to that, but not as robust as they claimed. But the right to international travel has been presumed by a good number of legal scholars in that space until this decision came down. So hopefully that will be challenged at the Supreme Court level, and clearly that will be another right at issue in the new Vaxport era.
Because it starts with international travel, but there's no reason why it doesn't become interstate, interprovincial.
Well, you got to experience that in Canada.
Oh yeah, and then there's no reason why it doesn't become intermunicipal travel. Then it becomes no reason why it doesn't become to use the public walkway travel. I mean, I experienced it firsthand. Now I'm still enraged. But they've eliminated it now. New Brunswick now no longer even has an indoor face mask mandate. Stores are just strongly requesting so that people don't panic. But the fact that they did it once It's the precedent. And now it's only international travel. Of course, you don't have the right to leave your country to go to another country. It's a privilege. I've said that myself at some point in my life. You see the way that privilege becomes an encroaching privilege. Yeah, the right to leave your house is a privilege. You are entitled to be free within the four walls of your house, but even then, not necessarily so. It's never-ending encroaching government that it's never-ending.
It's a misapprehension of the fundamental relationship between the citizen and the government. The government exists here for the citizen. The citizen does not exist here for the government. Everything is my right, and anything that you have is your privilege as the government. And instead, everything's becoming the government's right and prerogative, and it's only a privilege if they decide to extend it. And that's completely contrary. The reason why we have a constitutional government in the first place.
Yeah, and now Ian Hall says we already have a constitutional right to interstate travel. Sure, you do. As I thought I did in Canada, until they say in accordance with a free and democratic society, you don't have that provision in the United States. You just have Jacobson and you just have Dershowitz out there promoting the idea that you can travel unless it infringes on what I think my constitutional right is to get on a plane or to get in a train and know that everyone is vaccinated. Robert, you heard
you have a
Gershon
constitutional right to travel, but you can't get on a plane, you can't get on a train, you can't get on a bus, you can't drive your car over the border. But other than that, you have an interstate right to travel. That's why it's a crock right now.
And now I'm not trying to throw shade, as the expression goes with the youth, on Dershowitz. You had the debate with him. I disagree with Dershowitz on this. He was on Fox. It was Fox News. I forget the name of the woman that he was being interviewed by. He basically says he has a right to get on a plane and know that everyone has been vaccinated against something. COVID in this particular case. And I'm thinking, I don't know where you think you got that right from. If you think that that's your constitutional right, don't travel, because I don't think you have that constitutional right. And if you're so afraid of taking those risks, you should be the one to find an alternative means of transport and not imposing anything on anyone else's individual body. But I mean, you don't agree with Dersh now any more than you did before. I personally think I
recommend people go back and watch that debate. And I'll be talking more about specific vaccine suits and other suits at vivabarneslaw.locals.com this week to get into information that YouTube prefers not to be publicly discussed on its channel. But I agree with the legal standard, and Dershowitz agreed with the legal standard. There needs to be clear before anything can be mandated from a public health perspective. There needs to be clear and convincing evidence that it presents a substantial risk of severe harm for which no alternative suffices. Where I disagree with Dershowitz is factually. Yeah, well, he really believes that this is like the Walking Dead, and and that's where I think he's mistaken.
No, he said as much. He said it's worse than smallpox. I mean, I don't know. Yeah. I think that is
God bless him, but he's really got to quit reading the New York Times.
Well, this is what I say this with peace and love, and I say this not ironically. I say with true understanding. I do believe that he has been overcome in the same way everyone else or many people are in his position. A year and a half, 2 years of incessant media, fear porn mongering, and he's 80 and he's like, yeah, I just want to live the rest of my life in peace. And if this is the only way I think I can do it based on what I'm hearing, then yes, I think this is the new constitutional norm. And I've seen it happen to other people who are equally as intelligent as Dershowitz. I think he does not appreciate. He is blinded by his own fear and exaggeration of the issue.
It's why they never went through the evidentiary process, never went through the legislative process, never went through the democratic process, tried to avoid all trials at all times, because the stories that Dershowitz believes are stories that if he got the opportunity to witness those, what we've witnessed from every jury trial to date is that, or any judicial trial with full evidentiary hearings from Judge Stickman forward, is that the evidence doesn't purport to support and doesn't in fact support what they purported it did. And so that's the importance and necessity of it. It's why those methods need to be in place in the first instance.
To quote the leader of the party for which I'm running, Maxime Bernier, he put up a funny tweet, retweeted it. It's a flow chart. It says, if vaccines work, yes, no need for a passport. If vaccines don't work, no need for a passport. Either way, there was one branch of the arm that he was missing, which was vaccines only work when every single person on earth gets them. And still, we're not even sure that that's the case, even if that hypothetical could ever be achieved. But
exactly. And speaking of which, talking about this administration and COVID, the Attorney General, the governor of Texas, had ordered that they not allow illegal immigrants present in the United States that cross the border in Texas to continue to be out in public without some degree of safety concerning COVID, because people were finding that, in fact, they had known illegal immigrants with COVID infected, and that they were releasing them in the public. Not only that, they were transporting them all around the country without the knowledge of the local community or the consent of the local governing officials, and releasing them into that community. So the same administration that says people have to wear masks, people may have to get vaccines in order to prevent spread of COVID, is bringing infected illegal immigrants into the country and distributing throughout the country without any protective precautions. And because the Texas governor tried to do something about it, the Biden administration sued the state of Texas this week to try to prevent them from enforcing COVID rules as it applies to illegal immigrants.
So it is politics ruins everything. You have your oppression Olympics. I think it was Gadsad that used the term. You have your political hierarchy of risk and priority, and it's just egregious when you see the double standards that are being applied for political expedience on specific issues. It's truly discouraging, Robert. You might have to end us with a good one in terms of encouraging us, but there was one thing that I know we wanted to talk about before we got there. Do we have time for Coinbase class action? Because
sure.
I don't know much about it.
It's pretty basic. Basically, when Coinbase promoted itself as going to be like the main place you could trade cryptocurrencies and Bitcoin, et cetera, it went public with the SEC. And there were a lot of things Coinbase did during that time period that Coinbase promised certain degrees of privacy protection. Then they cut a sweetheart deal with the IRS and gave a lot of people's private information, so they were then tracked down. They also exercised super due diligence such that a lot of people couldn't even open Coinbase accounts that should have been able to. But the other thing they did is they said they were ready to go with their technology and capital to bring on everybody who wanted to be able to trade in Coinbase in order to push the stock value up when they announced it, their initial public offering. And now there's a class action because, of course, it turned out Coinbase was not being truthful according to the complaint, which is that they didn't have the capital. They had to end up borrowing money and doing other things. They did their technology really wasn't up to snuff, and not a big surprise that that's the case. Because, again, what was happening behind the scenes that I knew about was that Coinbase wasn't keeping a lot of promises, that they were going to be a very government-controlled, government-regulated entity meant to strip anonymity and, in many cases, strip the protection that cryptocurrency provides. Like those hackers, supposed hackers, that brought down the oil distribution along the East Coast. They made the mistake of storing their crypto, their ransom payoff, in a U.S. server. And which tells me maybe they definitely weren't Russian hackers. If they're a Russian hacker, that money would have been gone. But but what it showed is that it's people still being unaware the degree to which the government is using coercive power to get these corrupted institutions or corrupting those institutions to co-opt the Bitcoin cryptocurrency market space to basically undermine the purpose of cryptocurrency, particularly in the way in which it could challenge institutional currency or fiat currency or governmental power. So the fact that they were lying in this other capacity to boost their stock is not a surprise, but it's part of a broader picture with Coinbase and a lot of these intermediary companies. People think their Bitcoin is private. They think it's anonymous. They think it's that it's protected from government seizure. Not when it's in an intermediary like Coinbase. It ain't.
Well, my bigger concern than that is the liquidity of these intermediaries. What's to say that they have the liquidity to satisfy people's ownership in cryptocurrencies? Like what happens if they go bust?
Well, that's the problem. What it's created is a bunch of off-book entities. George Gammon did a good breakdown of this a couple of months ago and discussed it as Rebel Capitalist Live show, which is that if you dig into the a lot of these people that are sort of off-book or outside the borders of the U.S., a lot of them don't have the liquidity to back up what they're doing. And then they may be a lot of issues there too. Once every week, I see a fraud case brought in the Caymans concerning another crypto promoter. So what's happening is people are stuck between grifter outsiders and corrupt insiders, which is, that's a common recurrent refrain in a large number of contexts. Another example of that, briefly, Kaiser Permanente, was fine. Someone had brought what's called a key tam action, and key tam is a way for an ordinary individual, if you know of some anybody who has defrauded the government, you can bring a Quitam action, Quitam, on behalf of the government, like you were a private attorney general, exposing that fraud and misconduct. And then what can happen is the government can join the case later. You don't have to end up prosecuting it, but you get a percentage of whatever's recovered. Someone had outed a decade ago that Kaiser Permanente had been doctoring Medicaid and Medicare reports and getting doctors to go along with it. They were saying patients got treatment and diagnostic component it's called coding in the industry, that they never got in order to inflate Medicare bills to get really rich. And just now the government had been guilt shamed into finally getting involved in this case that had been pending for multiple years. But it gives some sense of where the government's priorities are and some sense of the trustworthiness of these big healthcare institutions, because you had major doctors in a major healthcare institution doctoring records for years in obvious fraud to make more money for themselves. And the government did very little and only did what it had to do at the end. And some of these same institutions are the ones you're supposed to trust for current record keeping about certain current medical related issues.
Well, Robert, with that said, enough of the cynicism. Reassure people that the world is not falling apart around them. And by the world, I mean reassure me as well, because the more I learn, the more I want to scrub from my brain. So leave us with something good for the week.
We won't have a sidebar this week, but we will have a sidebar next week. That sidebar guest will be Robert Francis Kennedy Jr., who continues to bring good fights. He's part of that case that are connected to works with the organization that brought that critical FOIA claim that it led to more transparency about these essential issues. Just like that Quitam plaintiff kept fighting away and got the government to finally expose this fraud by a major healthcare corporation. So, and Bobby Kennedy Jr. has spent, 3 decades taking on impossible cases and winning them and prevailing them at shocking rates, despite the extraordinary amount of defamation that has come target at him. So much so that right now, I think it was Washington Post or somebody listed him as the number 2 most dangerous disinformant person in the world. Anytime you get on that list, that's an honorable list. That's not a dishonorable list. And it shows the ability to continue to fight back despite the odds. And this is somebody who, as a teenager, saw his father assassinated for wanting to trying to stand up for what he stood up for. So it's more encouragement, more reason, more incentive, just like that Freedom of Information Act claim we talked about at the beginning. It showed that it forced more transparency. If you continue to fight back, that's the only way you can succeed.
All right, with that said, I see some people. I see people are getting cynical and getting not jaded, but what's the opposite of encouraged? Discouraged. Don't lose faith, and it's not a question. Do not become the monster that one is battling. That's where I just keep repeating that to yourselves, as well as the Serenity Prayer is always good to repeat. But the one that I found most useful is do not become the monster that you're trying to battle. And Robert, if nothing else, people should take that away from what we're doing here.
Yeah. The greatest trick the devil ever pulled was convincing people he did not exist. The greatest trick the system ever pulled was convincing you cannot resist. As long as you resist, then there's always hope.
All right. And any update on Kyle?
No particular update on Kyle's case. But for updates on that, the election cases, vaccine cases, mask mandate cases, I'll be discussing all of that this week at vivabarneslaw.locals.com.
All right, and with that said, everyone in the chat, thank you very much. Sorry, we did not simultaneously stream on Rumble. I think that was probably my mistake, so take for granted it's my mistake. Nothing wrong with Rumble. No sidebar Wednesday, which is probably good, Robert, because I don't think I'm going to have cell reception, but whatever. We'll see you Sunday. I'm going to be back in Montreal in my studio. Everyone, have a great rest of the weekend. Have a great week. Robert, thank you very much. Stick around. We'll say our proper goodbyes afterwards, and peace, everyone.